All right, everybody, here we go. It is now 12 o'clock here on the East Coast. That means it's time for the Zoom at noon, Garden State CLE Lunchtime Learning. Joining us again this week from Atlantic City, New Jersey at the State Bar Convention is the, I don't want to say honorable, so I'll just say John Menzel, attorney at law. What are you doing down there?
Look, Bob, I do drugs and drunk driving all over the state, and I represent people too.
All right, so this is going to be of a particular concern to you. Johnny, I want to get into this right away. Everybody should follow along with his lesson plan. And before we get into the OPA, I really want to talk about immunity as a general concept. What we've done today, too, is where our focus is going to be on immunity in the criminal context or quasi-criminal context, not in the civil context. And there's plenty of examples in civil law, tort law, cases involving governmental entities and things of that nature where there is statutory and common law immunities, but we're going to skip over that stuff. We got enough problems dealing with criminal stuff. So let's take a look at what the lesson plan says. As a legal concept, immunity is understood to provide a complete shield to prosecution for a criminal, and again, or civil offense if you're in the case. It differs from an affirmative defense in the sense that a defense usually has to be raised by the defendant at trial and is subject to being disproved by the prosecutor beyond a reasonable doubt. Common examples, and again, in the criminal context, include self-defense, insanity, statute of limitations, territorial and subject matter jurisdiction, and others. Johnny, any comments about this? I know you raised affirmative defenses. In fact, you got one coming up now with necessity, don't you?
Yeah, we have one in the appellate division now based on State versus Romano, the necessity defense, common law defense, not a statutory defense, where we'll see what the appellate division does.
Right. So basically, you're at trial when you have one of these affirmative defenses, necessity being a typical one. You would you have to raise it, but I don't know there's any burden of proof that you have necessarily. You just have to put it in play in the defense case, and then
Romano talks about some evidence, but all the other cases are much more precise in their articulation of the standard. It seems you have to raise it by a fair preponderance of the evidence. So I guess more likely than not, that kind of thing.
Well. But the issue then becomes, and there's no doubt about this, and once you put it in play, so to speak, as an affirmative defense, it's then incumbent upon the prosecutor to come back and disprove it beyond a reasonable doubt. I mean, we all agree with that, right?
Absolutely. I mean, it's funny, in that case, we had tactically, we did a motion to suppress. I got a lot of hearsay in, a lot of investigation the cops did to corroborate the necessity. And then we stipulated into the trial. And I suppose the prosecutor did that to be fair, although maybe he just didn't understand that I was getting a lot of inadmissible stuff in at the trial level.
You ought to be ashamed of yourself. All right. Now let's talk about this in the context of immunity. And this is going to be very interesting. You're going to see this is something that's unique in criminal practice. Absolute immunity, and there's not that many examples of it, but it just really is established typically through the common law. Absolute immunity exists through the common law in certain limited instances. Immunity is absolute, and the defendant does not have to prove anything. There's no elements associated with the immunity. The best example I can think of is our judges, who are completely immune from liability for damages based upon acts they commit within their judicial jurisdiction. I had a call the other day from a judge who said, "Listen, I've been served with papers in a civil rights case based upon a decision I made from the bench." All right. I said, "Let me guess, was this a pro se litigant?" And he said, "Yeah, how did you know?" I said, "Because lawyers would understand that you're gonna get out of this on summary judgment because you have absolute immunity for decisions you make from the bench." Okay.
You'd probably get out of it on a motion to dismiss the complaint without even filing an answer.
Possible, but the bottom line I want him to understand is that he has absolute immunity for the decisions he makes in the context of decisions that he makes for the bench. Be they wrong, be they poorly motivated, be they corrupt, it doesn't matter. You have immunity from any civil liability with respect to the decisions you make from the bench. All right. Now that's a rare exception because usually absolute immunity is it exists in the law. It protects prosecutors, protects witnesses who are testifying. I think it protects lawyers when they're making arguments before juries and things of that nature. But highly unusual to have absolute immunity. Most of the immunities are qualified, and by that I mean there are certain elements that the defendant has to raise when he or she is seeking to advance an immunity argument and get the case tossed out. Let me read. Well, actually, Johnny, you read this. All right, you have B in front of you there, qualified immunity.
Sure. I mean, look, with qualified immunity, typically, most measures of immunity are qualified in the sense that the defendant has the burden of establishing the elements of the immunity. Unlike an affirmative defense, a qualified immunity claim can and should be raised on a pretrial basis. If the defendant is successful in establishing the elements of the qualified immunity, the case must be dismissed. However, in the event the immunity application is denied pre-trial, it can be raised as an affirmative defense at trial and decided by the jury.
And this is a unique in the criminal law because it's kind of like a summary judgment motion, which you don't typically have in criminal practice. You know, the case just goes to trial. But if you have an immunity claim, you should raise that, or you can raise it before trial. And it's in the nature of a summary judgment claim, but you're saying, look, Judge, you know, we meet these particular threshold issues. If you find these things to be true, the case gets dismissed because of the immunity claim. There's several interesting things here that everybody should know about dealing with this from a procedural standpoint. And I'm interested in hearing how you would handle it as an advocate, Johnny. Immunity claims can be raised at any time during the proceedings. You can raise it pre-trial, you can raise it during the course of the trial, or you can raise it when you put on a defense case. It doesn't make any difference. I think the advantage for defense attorneys is to raise it pre-trial, and then if your immunity claim is rejected, you have a second opportunity to raise it during the course of the defense case as an affirmative defense, and the jury gets to make the final call on this. So in a very real sense, you get two bites of the apple. And Johnny, I'm concerned about hearing your opinion tactically, how you would handle this when you have a legitimate immunity claim.
Let's put it this way. The way we handled, for example, that it wasn't an immunity thing, but it was an affirmative defense. We did it as a pretrial motion in the context of a motion to suppress. It went in so well that, of course, we stipulated in before our jury of one, the guy with the black dress in the front of the courtroom there. And but the only tactical reason not to do it is if you want to really do it as a surprise. You don't want to telegraph your strategy to the prosecution. It's probably rare when you wouldn't want to get two bites at the apple. But of course, when you fully present it pre-trial, now the prosecutor is going to have a template to attack. He's going to try to overcome it.
The immunity claim is so broad that it actually there's some case law and that we're going to discuss about this from the appellate division, indicating that this is something you could even ask for to be considered by the grand jury. In other words, you have an immunity claim, and the immunity for, especially under the Opioid Protection Act, the OPA, is so broad that you're not supposed to be arrested or even charged if you have this immunity available to you. So that gives you the opportunity to pitch this whole thing to the grand jury.
So let me ask you this, Bob. If we're doing a motion to dismiss, we get the grand jury transcript, and we see that maybe they were aware of this exculpatory information. Are you telling me that it would be prosecutorial misconduct for the prosecutor not to present it?
Well, I think it would be grounds you have if it's palpable and the prosecutor was aware of it. It's, you know, the case law suggests that the prosecutor has an affirmative obligation when that occurs to present it to the grand jury and let them make that determination. Okay, it's like any other exculpatory evidence. You know, that's something that's really important. Prosecutor has an ethical obligation and a legal obligation to present that to the grand jury and let them make the call. But the point I'm trying to make is that if you have one of these claims and you can present it to the grand jury, it may be that your client gets no billed in the first place because the grand jury buys into the immunity claim, and that's the end of the case. And, you know, it never gets indicted, it gets no billed, and everybody moves on with his life. How you do that, though, I think since, you know, I guess there's a couple things you can do. First of all, you can't write to the grand jury individually. You have to go through the county prosecutor or attorney general, who's ever got the jury. And you write to them and say, look, this is the situation. I'd like you to present this particular evidence. In fact, my guy could testify, or these following people could be witnesses that would help sustain the immunity claim. And you may have lay people that are going to come in, or police officers, or whatever it is. And I think under those circumstances, if it's a legitimate good faith argument, the prosecutor is going to be duty bound to present that information to the grand jury.
Of course, now he's going to have another transcript. He's going to have another transcript that maybe he can use later on in a motion or a trial to try to cross-examine those same witnesses.
Sure.